Good afternoon to everybody, and welcome to our panel, which is titled Standard Oil to Microsoft Monopolization Cases and Their Effect on Consumers. And before I start, I should mention to the audience that obviously we will be taking questions, and you can type your questions into the Q&A tab at the bottom of your screen. In the last few months, the Department of Justice, the Federal Trade Commission, and state attorneys general have filed 5 major complaints against Facebook and Google, reflecting a widespread concern about a lack of sufficient competition in these markets, and that these companies have used anti-competitive means to gain or maintain their market position. In the 130 years since the Sherman Act was enacted, there have not been many major monopolization cases, but we do have some historical experience, from Standard Oil in the early 1900s to the Microsoft case 20 years ago, and including IBM and AT&T and several others in between. So an obvious question is, what are the applicable lessons from these cases? We have an outstanding panel to address this question, and I've asked each of them to give opening remarks addressing the question that specifically, what are the lessons from our historical experience with major monopolization cases? Our first speaker will be Randy Picker, who is James Parker Hall Distinguished Service Professor at the University of Chicago Law School, where he teaches and writes on antitrust, network industries, and secure transactions. Randy?
Thank you. And I've been told to speak for 7 minutes, so I just turned on the clock, and that's what I'm going to do. So, and since I'm first, when I looked at the title, it said Standard Oil and Microsoft, so I thought I should say something about Standard and then move forward. So that's what I'm going to do. So the Standard case is, in some ways, I think, an extremely simple case. It's a merger to monopoly case. So I think reading the lower court opinion, many of us have probably read the Supreme Court opinion. Lower court opinion, I think, is terrifically useful there. They're not opposed to, as it were, earned monopoly, I think, but that's not the Standard situation. Standard was a merger to monopoly, and so they say, look, we can apply sections 1 and sections 2 to that and break up Standard Oil. That's what they did. And that was all done under the Sherman Act because that was obviously the applicable law of the day. That seems simple enough as a starting point. Obviously, where do we go from that? And where we go from that is obviously the substantive standard applied to mergers changes over time. We obviously get both the Clayton Act and the Federal Trade Commission Act in 1914. We get new other legislation in 1950. But I think critically for our purposes, the procedures change in 1976 with the passage of Hart-Scott-Rodino. And Hart-Scott-Rodino moves us from a ex post regime to an ex ante regime. I was looking at the legislative history on Hart-Scott-Rodino yesterday and noticed 2 things there that you would expect to see. One is, as everyone calls it, the unscrambling problem, a concern about how do you break up mergers after the fact. That seemed to dominate the analysis leading to Hart-Scott-Rodino. Second thread there, though, as well. And that second thread says, look, we want firms to be able to do mergers and, as it were, rely on those. They're going to make investments. There are going to be choices they're going to make. And whether they are subject to subsequent breakup might have consequences for the choices they would make. So as you move to the 5 cases, Tom, that you talked about, the 2 Facebook cases, I think, are in the main focused on the mergers, Instagram and WhatsApp. Both of those mergers were looked at, obviously, by the applicable antitrust authorities, the Federal Trade Commission in the United States, the Office of Fair Trading in the UK issued like a 10-page document on Instagram. WhatsApp was obviously looked at by the FTC and then also the European Commission. I do think there are good reasons for the ideas articulated in the Hart-Scott-Rodino legislative history about how we want to incentivize investments, that the right time to challenge these mergers or to evaluate these mergers is really at the point of merger and not after the fact. I don't think Standard Oil tells us anything about that question. So Standard Oil stands for the proposition that in 1911 under Section 2, you could ex post challenge mergers, and that's perfectly sensible then. I think we're in a different legal regime now, and I think that's one of the questions we'll see in that case. All right, that was 3 minutes. I want to jump forward. So I am going to go to AT&T. Again, I think AT&T is a pretty different situation, and I'm sure Bob's going to talk about AT&T than the situation we have here now. So when I think AT&T, I think both the 1949 complaint and then the 1974 complaint. So in both of those were built on the idea that this is a very large enterprise. Parts of it are regulated, parts are not. Western Electric was not. And so the 1949 complaint wanted to break up AT&T to separate out the unregulated component, Western Electric, from the regulated components. And they thought there was a lot of cross-subsidization and, as it were, cheating on the regulatory structure, and that they were having trouble managing that. That's not what happened in 1956. The final judgment that emerges out of it, I think, is super interesting. I've written about it. We can talk about that in due course. But when we get to 1974, and again, they bring a new complaint against AT&T, it's again the same kind of thing. The scope is too big. We can't manage it. And we should separate out the regulated components from the unregulated components, or at least now the unregulated components to be. So that was Bill Baxter's vision with regard to the breakup. Remember, that was a consensual breakup. AT&T agreed to that. And we created these local natural monopolies that were going to be regulated and quarantined. And AT&T was going to go off and compete in the long distance market. Again, the firms we're talking about today in the digital marketplace, those are not yet, I think they may be soon, they're not yet regulated firms, right? I'm teaching a seminar at the law school right now on digital marketplaces, and we're reading the UK materials and the Australian materials and the European materials. We're heading down a regulatory path there, but we're not there yet. And what animated the AT&T cases, both in 49 and in 74, was this concern about how do you deal with this entity that has regulated parts and unregulated parts. And that doesn't match very well to the entities we're talking about here, at least today, in terms of the 5 suits filed against Google and Facebook. All right, I have 2 minutes. I want to switch to IBM and Microsoft. I think both of those cases are much more interesting for the current day, because I think both of those cases are about the scope of products. So the 1969 suit filed against IBM, the heart of that lawsuit was IBM's practice with regard to bundling together hardware, software, and services. And that made it hard for people to compete in the services market, compete in the software market. The government wanted to try to jumpstart competition, and the IBM pricing structure was interfering with that. That was the heart of the suit filed in the very last moments of the Johnson administration in 1969. IBM 6 months in said, great, we're going to change. And then the case ran on for 13 more years before it was dismissed. So, and I think the pendency of that lawsuit affected the design of the IBM PC in 1981. We can talk about that. That's really interesting. But again, I think the product boundary issues in that case, maybe that matters for how we want to think about Google, maybe less so about the Facebook case. I think the same thing about the Microsoft case. So the Microsoft case is really obviously at the edge between the desktop era and the internet era. Netscape Navigator, you know, with its roots in government work at Champaign, Illinois, in the Mosaic, and obviously Tim Berners-Lee at CERN in Switzerland. How we define boundaries between the desktop operating system and the internet world that was coming, that is at the heart of the Microsoft case. That case was litigated under pretty severe constraints. Each side could only put on 12 witnesses. So I think it's important to read that case. We're going to have lots of witnesses in the Google case whenever that takes place. And we're going to see what that looks like. I'm at 7 minutes and 15 seconds. I'm going to stop.
Thank you, Randy, and thank you for being so rigorous about the time. Our next speaker is Diana Moss, who's president of the American Antitrust Institute, position she's held since 2015. And prior to joining AAI, she was at the FERC coordinating competition analysis for electricity mergers. And she is also an adjunct faculty member in the Department of Economics at the University of Colorado, Boulder. Diana?
You're on mute.
Mute. It gets you every time. Apologies for that. Thanks, Tom, and always a pleasure to be here with DEI and my co-panelists to share ideas. Just a note, I'm not going to comment on the merits or probable outcomes of the recently filed cases, but just wanted to highlight some of the major economic and policy issues that underlie them. So to begin, I think it's useful to remind ourselves that the purpose of antitrust is twofold. One is to prevent consumers and workers from getting ripped off from the exercise of market power through price and non-price effects. And a second is to prevent the concentration of economic power in the hands of a few. So vigorous enforcement promotes an equitable distribution of wealth and income, and it also protects markets, society, and underlying democratic values. All previous Section 2 cases, Standard Oil, AT&T, Microsoft, really reflect these sort of underlying values. I will be controversial, of course, and say that antitrust has largely taken its eye off the ball on these goals over the last 4 decades by giving just excessive deference to claims of pro-competitive effects from mergers and exclusionary conduct. And, the chickens have come home to roost. After 4 decades, we now see massive consolidation, high concentration, and evidence of damage wrought by this very hands-off laissez-faire approach. Digital tech, no exception. AI's empirical work shows that Section 7 of the Clayton Act has been under-enforced in big tech. And until a few months ago, we had no monopolization cases in digital technology. Now we have several, with enforcers competing to produce the most innovative and legally compelling complaints. And moreover, since those cases have been filed, the magnitude of the economic, social, and political issues raised by the digital ecosystems has become more clear. I, for one, have spent lots of time in discussions over the last couple of weeks about whether, for example, if there were more competition in microblogging, would we have seen stronger enforcement of content moderation rules and less hate speech, which has contributed largely to a lot of the unrest we've seen in the last month or so. So this highlights fundamental questions about the role of antitrust and competition policy in addressing the issues raised by the digital ecosystems, but also shines a light on the importance of other policy tools such as regulation that will also be needed. So suffice it to say, we've seen a weakening in a very laissez-faire approach to big tech on the antitrust front. And so the question is now, how has this become evident and what does it mean for consumer welfare? So a few thoughts. First, enforcers are alleging violations in these most recent cases that really do reflect durable antitrust concepts and theories of competitive harm, such as maintenance of monopoly. So there's nothing startlingly new here relative to the competitive effects alleged in Microsoft or Standard Oil. The conduct is just housed in a very, very different business model. Second, I think enforcers have really proven willing to push the consumer welfare standard to its full capacity. The Facebook and Google cases allege harms through price and non-price effects, depending on the markets involved. Notably, non-price effects include degradation of the quality of user experience through the abuse of their data and their privacy. Price and non-price harms are clearly reachable under the consumer welfare standard. AI has been highlighting this for years, but a lot of the conversation over the last couple of years has really been wastefully diverted by misinformed arguments that the consumer welfare standard reaches only to short-term price effects. We now have evidence that proves otherwise. Third, I think enforcers now realize that the rapid, unconstrained growth in the digital ecosystems is evidence of antitrust's misplaced obsession with error cost analysis. So many of the assumptions that underlie error cost analysis don't work well in the digital ecosystem markets. And why? Well, the value proposition is essentially a multi-product monopoly on steroids. The digital ecosystems are built on perpetuating connectivity across an ecosystem of markets, maintaining dominance in some core markets, and keeping threats of displacement of those monopolies at bay by acquiring or replicating rivals. So bigness is really integral to both competitive effects analysis and efficiencies analysis, and makes the application of error cost much more complex. Finally, I think it's clear that enforcers are really taking the full measure of the digital ecosystems as a unique business model and what that means for enforcement. That includes sort of economic phenomenon and technological dynamism that drive bigness, such as winner-take-all markets, scale and scope economies, network effects, platform economies. But enforcers, importantly, are also recognizing that because of these very features, they've been pressured to accept specious arguments that the value of user engagement in the digital ecosystems should overwhelm any and all anti-competitive effects. So I think all these developments are good news for promoting consumer welfare through enforcement of the laws. But I will finish by saying that there's still a lot to learn about the digital ecosystems, and that will directly affect antitrust analytics. For example, the digital ecosystems are rife with market failures, information asymmetries regarding consumer privacy, data externalities, and all of this will fundamentally affect consumer behavior. There's also evidence from the marketing research over in the business schools that consumers make suboptimal choices in these preference shaping environments. Consumer preferences are not accommodated in the digital ecosystems, rather they are shaped through algorithmic recommendations. That's a very different mode of how firms behave. I also think that antitrust really hasn't fully grasped how data and data enrichment through the application of artificial intelligence, machine learning, data analytics drive the value proposition and at the same time create barriers to entry, which is why AAI wrote a letter to DOJ urging them to review the Google Looker deal. So all of these concerns ultimately affect antitrust analytics, market definition, efficiencies claims, and remedy. We've had some sneak peeks into the disarray created by this with Amex, Fairlogic, et cetera. I do worry because the digital platforms are really on the brink of another round of expansion. And I think that will have significant implications, especially for remedy in these cases. So careful consideration should be given to the role of data and data enrichment in powering the digital ecosystems. And we really need to carefully evaluate the options on the table that have been put on the table, for example, breakup discussions versus other types of remedies. Thank you.
Thanks, Diana. Our next speaker is Michael Katz, who's Professor Emeritus at UC Berkeley's Haas School of Business and the Department of Economics, where he holds the Sarin Chair in Strategy and Leadership. He is a former Deputy Assistant Attorney General for Economics at the Antitrust Division, and also a former Chief Economist at the FCC, and has published numerous articles on the economics of network industries, intellectual property, telecom, and antitrust. Welcome, Michael.
Thank you. It's a pleasure to be on the panel with my fellow panelists, and thank you for inviting me. I want to start with a disclaimer as well. I've worked for and continue to work for some of the companies involved in some of the big tech lawsuits. And I will also not be commenting on the merits of specific current cases. And may imply some things about some past cases. And what I want to do is talk about a couple of lessons, I think, from past cases. And I want to draw, though, also on cases in the European Union, since the European Commission, right, in recent years, everyone knows, has been much more aggressive than US authorities have been. So one thing I want to start with is an old argument that's been made, or it's become old. It was certainly something you heard a lot with Microsoft. And that is this claim that, look, we ought to give up on antitrust because technological change is so rapid that by the time you get around to the case being concluded, you know, you're fighting the last war, and that the firm that you're accusing of being the monopolist no longer has market power. And that, I think, has just been wildly exaggerated and is wrong. And first off, it's true. Cases take a long time. With Microsoft, the FTC started investigating Microsoft in 1990. The Justice Department then brought a case in the mid-90s. And when the remedy, to foreshadow something I'm going to come back to, when the remedy in that turned out to be hard to enforce and disputed, the DOJ brought what we now think of as the Microsoft case. And that didn't get through the appeals until 2001. Okay, in the case of Google Shopping, the EU opened the investigation in that in 2010, and that's still under appeal. So there is no doubt that these big cases can go slowly. And as you know, as Randy mentioned, the IBM case was the famous 13 years, and the Judge Bork called the Vietnam of antitrust. Although I think in that case, it's also been told that that was IBM's strategy. They were actually trying to outlive the judge and succeeded, which then really gummed things up. In any case, well, litigation moves slowly, so do some of the markets. I mean, 5 years after the remedy in Microsoft was put in place, Microsoft still had a share of over 90% of PC operating systems for or desktop operating systems. And the recent figures I've found, which I think are somewhat more unreliable, though, are from 76 to 88%, with almost all of the residual being Apple. Now, it's true that doesn't count mobile systems, iOS and Android, but it's clear for a lot of things those are not substitutes. And so it's just not the case that sort of, Microsoft faded off as a, long forgotten monopolist, or now just some minor competitor. I think actually, if you look at Microsoft, the biggest problem was the pace of political change was faster than antitrust, because you saw a new administration with a very different view on remedies. And the same thing with Google, right? It's been a long time, but I don't think anyone with a straight face would say, oh yes, Google has been swept aside, technological developments mean that Google search is no longer important. Now, look, in any event, there may well be cases where technological change is too fast, but it's something we have to look at on a case-by-case basis. This can't be a get-out-of-jail-free card. And really what I think is the most important point, though, is that the pace of technological change is endogenous. And right, given the increasing returns to scale we see because the creation of IP has big fixed costs, and all the issues with the collection and use of data and with network effects, right, we know these are often winner-take-all or winner-take-most markets. And what that means is a few things. One, it says entry is really important. And also it says innovation is really important, because the only way to enter successfully may be to innovate. And so what that does is it puts a premium on understanding what's driving investment, entry, and innovation. But also it means looking for conduct that might block it. And in fact, you go back and look at the Microsoft case, the big one. Microsoft essentially was saying, look, you shouldn't worry about us. We face such competitive pressures. Sure, maybe we look dominant today, we could be swept away. And then the DOJ, and they changed their theory a few times. So by the end, the DOJ was saying, but that's precisely what this case is about. You are taking actions to stop that process from occurring, and you're essentially trying to short circuit the Schumpeterian competition. So I think one thing is a really important general point is that Schumpeterian competition doesn't eliminate the need for antitrust. I think arguably it heightens it. I think what it does tell you is you've got to look at different things, and you should worry about different conduct, and it may tell us we should worry much less about static harms and prices, but it tells us then we really need to focus on conduct that potentially harms the dynamic process. Now, despite saying, oh, I think it's, these issues due to the pace of change are exaggerated, I do think they are an absolutely huge problem for designing an effective remedy. And just let me comment on a couple. I mean, I think one of the big lessons we get from past cases is that coming up with effective remedies is really hard. And let me just talk about a couple of classes of them. So one, right, is thinking about things like structural separations, line of business restrictions, or even thinking of something just trying to define the boundaries of products. And I think what we've learned is, it's fashionable to say, oh yeah, structural remedies, those are much better. They're self-executing. They're way better than conduct. But I think history shows they've had a lot of problems. We've already, AT&T is certainly were. In the case of Microsoft, the intermediate justice case that preceded the famous case ended up, they got big fights over the meaning of the consent decree, because it was trying to stop Microsoft from bundling other products into Windows. But then there was no agreement between Microsoft and the Justice Department on when something was another product being bundled in versus it was just a new feature of Windows. And while I was a supporter of the government's ultimate case against Microsoft, I actually said to Joel Klein at the time, it seems to me it's a losing battle, and it's actually a mistake to try to define the boundaries of what it is to be an operating system. And I think that's a problem with all these things. It's going to be, again, we're talking now about platforms maybe playing different roles, or these ones that are advertising based, but I think we're still going to see the same issues. And you see that, I think, a lot of this is because when you have software, once you've developed the software, the marginal costs of deploying it are really low. There can be benefits from the different pieces of software, you know, really knowing the other one is there on the system and they can interoperate and having the designs coordinated. And so all of that leads to this, I think, sort of natural tendency to expand what's in, say, something like an operating system. And so I think that's a real struggle for antitrust. And as I say, we see these remedies, you know, again, the EU tried this with Microsoft. They said, can't bundle in the media player, you need to offer it separately. And that famously failed as a remedy. So, I mean, I think there's some real problems there. Another thing I want to say about separation is, look, there are all these concerns about self-preferencing by platforms, and if they have an app or a product on their platform that they're going to favor it. And there are reasons to think that can be a problem, although I've also pointed out on that we've been down this road with cable television, and I think you can find people who will say with 100% certainty that cable television the cable television systems operators favor their own programming, and that's a competitive harm. And there are also people with equal fervor will say that what you're seeing is efficiencies because they're eliminating double marginalization. I think we're going to, you know, continue to see those battles. But a big point I want to make is structural separations is not by itself going to get rid of discrimination or the fact that a platform may, can favor some of the apps or users over others, or can even operate to create anti-competitive effects, because you still can have incentives at an arm's length to work with some of the users or apps or whatever to favor them. And in fact, this is, you know, the flip side. There are the people who say we shouldn't credit vertical mergers with efficiencies because the firms can do it by contract. Well, then there's the mirror image argument that says you shouldn't think that vertical disintegration is going to solve competitive problems, because competitive problems can be created by contract. So it may just move for the locus of concern from sort of internal operations to external contracts, which some people might, and it may be progress in the sense that that may be easier to monitor and understand. Let me say just a couple of things and then wrap up. Another one that people have thought about because of self-preferencing and saying, okay, well, maybe we won't make you actually separate, or even if we do make you separate because of the problem I just mentioned, for either of those reasons, we're going to impose non-discrimination remedies. Well, the thing is, a lot of these people are talking about it with sort of various forms of search or something like that, and that includes, you know, obviously Google, but also Amazon. And if you think about it, the problem is, when you're asking for unbiased rankings, you're basically saying we want non-discriminatory discrimination. Because the rankings, right, you are picking and choosing. That's what the benefit of the rankings is. So then to get in this notion of what you mean by unbiased, I think turns out to be an incredibly hard thing to do. These algorithms are complicated. If you're clever, right, you could pick something, you say, well, you know, we didn't know it would favor us, but in fact you did know. I mean, you can do these things obliquely. And I think the EU is learning that in the Google shopping case, right? They put these remedies in, and I think the EU itself has concluded that the remedies really haven't worked. Now, it may be that the problem there is there was nothing to remedy, and therefore the remedy didn't have the effect that the EU wanted, but I don't think anyone thinks that the remedy has somehow successfully cured a problem. So the last thing I would say is it may be, okay, and I think, you know, Randal alluded to this at the beginning in some ways, that the case itself is the remedy and it would change behavior. Some people have said it's because the follow-on litigation with just you know, the cost of the litigation itself or the potential treble damages, it basically serves as a deterrent as opposed to a remedy, but it's what gets the firm to change its behavior going forward. And, you know, arguably, right, that is some of what happened with IBM. IBM, you also see the downside is that probably being dragged through the litigation just hurt the company in ways that weren't good for anybody. And arguably, it's one of the things that happened with Microsoft. It got them to pull back some of their behavior, not because it was in a consent decree, but just they didn't want to go through this again. So let me stop there. Thank you.
Thanks, Michael. And last but not least is Bob Crandall. Bob's research focuses on antitrust and regulatory issues in the telecom sector. And he's the author or co-author of numerous articles and books on those subjects. He was acting director, deputy director, an assistant director at the Council on Wage and Price Stability, and has been a consultant to the Antitrust Division, the FTC, and the Treasury Department, and has taught economics at Northwestern, MIT, and other universities, and been a senior fellow at the Brookings Institution. He is an adjunct senior fellow at TPI. Bob?
Thank you, Tom. It's a pleasure to be on with my distinguished colleagues here. And I'm going to follow up at least on a lot of what Michael had to say, because I think designing the remedy is an important part of Section 2 monopolization case law. I'll also address some of the things that Randy had to say. But first of all, we have to ask ourselves, what is the purpose of invoking Section 2 now or at any time? Is it to deter anti-competitive practices, to penalize firms for their abuse of dominant position, a la the European Union, or to attempt by some sort of judicial decree to restructure an industry in order to provide a more competitive marketplace? My reading of Section 2 cases, and by the way, my disclaimer goes back 20 years. I was hired as a consultant to Microsoft, and I was to testify in the remedies phase, a responsibility which I didn't have to exercise because Judge Jackson decided he knew enough, he didn't need a hearing, right? And as a result, he was overturned. But my reading of Section 2 cases, and particularly the landmark cases, is where we've tried to use Section 2 to restructure an industry. And the easiest one was the one Randy mentioned, Standard Oil, finished in 1911, requiring the Standard Oil Trust to split off all the operating companies that had acquired over the years that were in the trust. My reading of that is that didn't have much effect on competition in the petroleum industry for two reasons. One, the spinoff was done equiproportionally among all the holders of the previous company, so they all had the same interests at heart initially. That would go away over time. But secondly, more important, there were new oil discoveries out west and eventually in the southwest that thoroughly dissipated Standard Oil's any Standard Oil monopoly. Fast forward all the way through Paramount Pictures and all the others, which went on forever, to AT&T. I've always felt, in retrospect, that the defendant in the AT&T case should have been the Federal Communications Commission, because had they established equal access for the emerging long distance companies, which came in because of a technological change, that is a development of microwave communications, they could have easily accomplished everything that or virtually everything in the long distance market that the structural separation of AT&T from its operating companies did. They also, of course, would have had to establish a reasonable set of access charges, which they did after the divestiture, but they could have done it without the divestiture, and we could have been spared the necessity of breaking up AT&T and watching it coalesce again. And to show you the problems of forecasting the future, keep in mind that in the AT&T case, there were two platforms that came to erode the local monopolies of the Bell operating companies. They were wireless and cable television, which expanded into two-way services and obviously to voice and internet broadband services. In the decree that broke up AT&T, the operating companies were allowed to keep the wireless companies. Had anyone realized how important wireless was quickly to become as an alternative to the bottleneck monopolies of the AT&T landline operating companies, you certainly wouldn't have done that. Now, fast forward to today, we can talk about, oh, by the way, one thing about the Microsoft case, that Michael, I don't know if you looked at the numbers, but clearly the question of whether the new tablets and wireless devices compete with the PCs that most of us are on today, I guess most of us are on, is an interesting question. But once Google integrated backward into browsers, it began to displace Microsoft very quickly, particularly in the wireless and even in the PC space. But since they introduced that browser, Microsoft stock has wildly outperformed Google stock. That's an interesting factoid to think about why Microsoft has done so well, despite the fact that they lost a very large share of that market. Now, at the present time, I can't see how we could possibly decide how to bring a remedy in either the Google case, the Facebook case, or any other digital platform case that might come up in such a way as structurally to restructure the market and create a more competitive marketplace. Chances are what we're going to focus on, other than the divestiture perhaps of Instagram and WhatsApp, is a variety of behavioral remedies. And these behavioral remedies, whatever they are ab initio, are going to have to change over time because of the way in which this marketplace is changing, which means we're going to have a court supervised decree for some period of time and maybe a renewal of such decree. And not only that, but what we now have is the expert panels that are being put together, telling us how to apply antitrust in the digital age, saying, well, we're not sure we can even figure out what the remedies should be. What we really need is a digital regulatory commission. The George Stigler Center at the University of Chicago is in favor of establishing a new regulatory commission to regulate the digital platforms. And of course, the Furman report from the UK had the same recommendation. That tells us a lot of what we need to know. People who have looked at this intensively cannot figure out very well how to structure a remedy, which means that we're going to get into, if there is a successful antitrust case, we're going to get into the very uncertain world of how to structure the remedy and how the remedy should be adjusted. Going back to the AT&T case, remember the case was brought in 74, a decree was signed in 82, the divestiture occurred in 84. It created such a problem in the court administering the decree that we had to get legislation in 1996 in order to clarify how we were going to admit competition into local wireline markets. And this continued until 2005. So we had 31 years of antitrust. And in fact, it all ended with cable television and wireless being the competitors, not these new entrants who were lured into the market by the 1996 Act and who spent somewhere between 37 and $50 billion on CapEx. We don't know what happened to it all, but most of them went bankrupt. It was not a good spectacle. That 37 to $50 billion that was spent by the competitive local carriers after the 96 Act, of course, has to be set up against $100 billion or more of benefits from the long distance market, which ensued, but which could have ensued without the antitrust decree. It could have simply ensued from a regulatory decision by a commission that was not prepared to make the right decision. I worry that the road we're going down now is to establish another commission, which will look like the FCC and which will make similar errors. I'll stop there.
Thanks, Bob. Well, let me ask a couple of questions to try to crystallize what many of you have been saying. These are all great comments, and obviously, there's a lot of doubt about. There's a lot of concern about the difficulty of fashioning effective remedies. But just to kind of put a point on it, what do people think, based on our experience with past monopolization cases and the nature of the companies that are involved in these cases, what do people think about the prospects of, well, first of all, have the past cases on average, have they improved consumer welfare, increased consumer welfare in your judgment? And secondly, what are the prospects for any of the current cases improving consumer welfare in terms of either lower prices, higher quality, or more innovation? And anybody, I'd like if all of you would answer that briefly.
Well, those are hard questions, but I'm happy to start. So look, I think, wow, I think that's so hard. So look, I think the 1956 AT&T settlement is incredibly interesting. On the one hand, the final judgment, it cements the licensing regime that AT&T had started. AT&T, when this suit was filed in 1949, had the future in its hands. That future was the transistor. They had invented that. And the 1956 settlement final judgment does two things. It opens all of those patents up and the world of semiconductors emerges from there. That undoubtedly had huge benefits. AT&T might have done that licensing before, even anyhow. They were already licensing even before the 56 final judgment was put in place. At the same time, the line of business restrictions kicked AT&T out of the computer market. IBM rises. Would IBM have had the same power if we let AT&T compete? Okay, I just throw up my hands at that point. The 1982 breakup of AT&T, I thought what Bob said on that was really interesting. It is amazing how little attention wireless gets in that at that time, just extraordinary. But I want to say what really mattered there is at the time we were ready to do wireless, when we started holding very large spectrum auctions in 95 and 96, the fact that we had 8 large firms, I suspect, changed how those auctions worked out. And so even though no one had that idea in mind when we broke up AT&T, having these large, sophisticated competitors, I suspect, changed how wireless rolled out, and the world we live in is based on that. All right, I'll stop there.
Anybody else want to weigh in on my question?
Yeah, I'll weigh in really quickly. Randy's right. They're very difficult questions. I think it kind of goes without saying that the outcome in AT&T was on net very positive for consumer welfare and also for innovation. I mean, it gave birth to the whole restructuring of the industry, gave birth to the wireless industry and accommodated sort of a natural flow or movement of technological change. I mean, ideally, a remedy can do that, can accommodate parallel technological change. Microsoft, very different, very political outcome with a hard swerve on a divestiture remedy and silly, ineffective behavioral remedies. I think these cases, these Section 2 cases, stand to really move the needle on many things that I pointed out in my earlier comments. And by the way, we're not commenting on the merits of the cases, because we want the cases to flow on their own merits and their own power. Where AAI is a nonprofit organization, nonpartisan nonprofit, but we think the cases are very strong, and we want them to gain traction and credibility and positive outcomes on their own without us weighing in on legal concerns and issues. But I think in the digital ecosystems, as we've all said, it's really all going to be about what's the effective remedy. And what I struggle with, as an economist, highlighting what Michael said, is crafting an effective remedy in a digital ecosystem is as yet untested and raises all sorts of issues that we haven't dealt with in past monopolization cases. The value proposition of the digital ecosystem centers around the collection and enrichment of data and data processing capability. I think we see entrenched platforms that are not going to be displaced. They may be eclipsed by other entry, but they're not going to be uprooted or displaced. And so if data is so central to the digital ecosystem value proposition, then I would like to see more discussion about remedy around data. But the problem there, of course, is that the market failures, the information asymmetries, different consumers having different preferences for different levels of privacy, all of these things are going to make it very difficult to craft a remedy, an antitrust remedy that will on its own take care of these problems, which is why I think antitrust is a tool that will have to be paired up and complemented by other policy tools, like some form of regulation, whether it be social regulation, addressing privacy, free speech, all those types of things. So antitrust is really facing a very difficult problem with remedy that I do not think can single-handedly achieve the outcome of promoting consumer welfare. With that said, I think consumer welfare in these cases, if you're not talking about advertising markets where they are positive price markets, but rather the zero price markets, these cases stand to really advance the ball in a positive way on non-price effects as being reachable under the consumer welfare standard.
Yeah, can I respond to that?
Yeah.
You want?
Yep.
Okay. First of all, it was not necessary to break up AT&T in order to get competition in the wireless business. Every other country and none of the other countries did break up their integrated monopolies, whether it's France Telecom or Deutsche Telekom or even BT in the UK, and they ended up in the same place we did, namely with 3 or 4 national wireless carriers, a highly rivalrous, if not competitive market. Secondly, I guess if we can't figure out how we would structure a decree and we end up giving a nod to having to have some sort of a regulatory commission take care of these problems of digital monopoly, then you wonder, why do we need antitrust in the first place? But then finally, addressing Diana's last part, I think that's a very interesting point. The question is, where's the market failure here? And it seems to me the market failure, or at least a major market failure, is the fact that these companies are able to collect our data at 0 price. Why hasn't someone been able to enter and offer me money for my data and bid me away from Facebook or Google? I guess Microsoft, a little company of what, $1.6 trillion or something today, has tried it with Bing, but I don't know how aggressive they've been. They don't seem to have succeeded very much, since they only have about 6% of the search market. Why hasn't, what is the source of the market failure there, and how are we going to address it? And how's this antitrust, how are the antitrust suits going to help?
Of course, one of the things that has been suggested with respect to data, if data is, that's a little bit, not quite on Bob's point about why that business model hasn't developed, but some people have suggested that the reason these companies are so entrenched is because they have so much data, and that the remedy for that is to have some mandatory access regime to in terms of data sharing. What is the panel's view on that?
At what price?
Well, that's obviously, that's part of the.
Who's going to set the price?
That's part of it.
Can I just say one thing before you move on that, but some of the that Bob was raising though about with data and why these other models, why I have an entrance come in. First off, people are getting paid for providing their data. I mean, that's what they're getting paid in kind. I mean, that is what these services are doing. But it struck me that I think if we look what the market failure is, a lot of it is, I think it's been a lack of disclosure, and it's, in some ways it's a consumer protection issue, maybe more than an antitrust issue, although ultimately, clouding consumers' information turns out to be an antitrust issue, right? Because it makes it difficult to compete. So that's just on that. But on this thing about the data, one of the particular version of that is people said, okay, we should have it that every individual owns his or her data. And I just see that as having a lot of problems as well, because first off, on a social network, we're getting all these issues. Well, what does it mean to be your data? And it's, your social graph, is that yours, or is that something you have owning jointly with a whole bunch of other people? Now, in my case, it's not a problem because I don't have anybody else in my social graph, so I do control it. But people with lots of friends, you're potentially violating their privacy. So I think that's a huge issue. I think there's also this thing of what does it mean to be your data, given that these companies may do a lot of processing of it or combining data from multiple different sources, or the fact that they're tracking you. So I think there are big issues there about the ownership. And the other thing is, though, that we also shouldn't forget, I don't think we really mean that we're going to let people own their data or at least say, okay, it's yours, you can do whatever you want with it. We're going to actually have to apply antitrust there, because otherwise you're getting this well-known issue. If some companies would say to everybody, look, give us your data, agree to go with us exclusively. Any one consumer says, oh, I might as well do it because what I do clearly isn't going to affect entry. I'm too small to make any difference. And they've offered me, some token worth, I can buy half a sword on some video game or something. So sure, I'll sign up. Everybody signs up exclusively, and then it's, you're right back where you were before. So you're actually going to then have to have antitrust, I think, intervene in what sort of contracts people can have, and what you're going to be allowed to do when you sell your data. So I don't think it makes the problem go away. That said, I think there are a bunch of benefits to data portability. I just think this whole notion of the ownership and portability is just way harder than the proponents give it credit for.
But on the question of, I mean, if we do get a regulatory agency, it seems to me that one of the things that's going to be certainly, whether it'll be done or not, is certainly going to be high on the agenda in terms of being discussed, is some sort of mandatory data sharing. And you know, that's a pretty dramatic proposal. It's got obviously the problem that Bob mentioned, at what price, and you know, data sets are not static, you know, they change all the time. So I mean, is this an idea with any merit at all?
Can I just point, I just want to answer that question, but follow up on what the very good points Michael just made. And that is, you know, because data and data enrichment is the lifeblood of the digital ecosystem. I mean, that's how they run. That's the fuel, the gasoline, the grease, whatever you want to call it, to create connectivity across these markets. Because it's so central, it should be the focus of any discussion about remedy, which is why I worry about these breakup discussions, which really miss the point, you know, completely. We're talking about reducing incentives and ability to exercise market power. But the fact that there are so many cajillions of users on the platforms, because the platforms cannot write contracts with individual users, they are essentially, you know, doing the equivalent of price discrimination, but on the data side, with no price really attached. It's information discrimination or attention discrimination or whatever. And they're pushing out recommendations to users through algorithmic preference shaping, which is a fundamentally different thing than preference accommodation that you would see in traditional manufacturing types of models. Because some users don't even know how much they value privacy, they say they value privacy, but then they give all this, they splooge out information into the digital ecosystems in a way that absolutely contradicts what they just said about how they value their privacy. So because of these complexities, yes, it would be nice to have a market to take care of privacy. I don't think a GDPR type instrument is even going to scratch the surface of the problems created by the role of user data enrichment and preference shaping. And I don't think antitrust is really well equipped to you know, craft a remedy in this way. I'm not saying antitrust shouldn't craft a remedy. Absolutely it should, but it's going to have to work in complement to some sort of regulatory approach, which, you know, as yet to be determined. And as a former regulator myself at the FERC, man, did we spend a lot of time talking about regulatory remedies in conjunction, coordination with antitrust remedies. We were, you know, almost on the daily in there with DOJ talking about how a regulatory remedy does or does not conflict with an antitrust remedy. And that issue absolutely will be a major issue in the coming years.
Let me there's two other kind of topics, or actually there are more, but that I'd like to get to before we run out of time. There was an interesting article in the Wall Street Journal over the weekend, quoting, obviously the issue of content on the internet has been very much in the news lately and very controversial. So the interesting article basically quoting Richard Epstein as saying that as far as content is concerned, these large platforms should be basically be considered common carriers, and therefore they should be obliged to accept whatever content comes along on a some sort of fair and non-discriminatory basis. What do people think about that idea?
Well, that's getting us into a completely different issue, and that is,
well, if they're common carriers, then
But then the question is, does a common carrier have an obligation to share data? And if it does so, how do you set the price? And then you got those 9 or 10 years under the 1996 Telecom Act trying to figure out what the terms are for an entrant to access the information and the facilities of the incumbent.
Right.
Yeah, I want to say, I think the pricing issue and the common carrier issue are different, right? So you could obviously say no sharing of data, but you have to post anything anyone wants to post, right? And look, it's a lot like what Diana's been saying. That's not an antitrust remedy. That's not an antitrust framing. That's a purely regulatory framing. We've got an ancient, the topic here was history. We've got an ancient history associated with that, right? That kind of regime goes back at least as far as the Interstate Commerce Act of 1887.
Right.
So we have tools for that. I'm not sure, look, we can make regulatory decisions, or democracies can make those decisions. We haven't done that so far, obviously. It'll be interesting to see what a new Biden administration is going to do.
Keep in mind that the establishment of the FCC in 1934 was in no small part designed to replace antitrust as a way to govern AT&T, as a substitute for antitrust. The question is now, if we're going to get a regulatory commission for digital platforms, will that legislation vacate any antitrust decrees that might have been put in place in the interim?
Sorry, Tom. If we do end up with a Digital Markets Regulatory Act that specifies that there will be a digital markets regulator in the US, much like we're seeing in Europe, obviously a savings clause would be top of the list priority to preserve the role of antitrust. So we avoid Trinco and Credit Suisse type disasters. But I can tell you again, as a former regulator, that crafting and administering an open access regime is not without peril. FERC has been tied up in the DC circuit for 25 years now on open access, in large part because of some sort of underlying structural factors. So it's not a panacea. That doesn't mean that it's not important or necessary to think about.
So look, we haven't really talked about merger policy. So let's end on a little talk about merger policy. Some obviously, in particular in the Facebook case, a major element of that case, in many people's view, is that a couple of mergers that occurred shouldn't have been allowed to occur. So the question is, and this has been proposed by many people, the question is, should we change merger policy, at least for some class of companies, in the way that places more of a burden of proof on the merging parties to prove the benefits of the merger, rather than just putting all the burden of proof on the government to prove the anti-competitive effects? Michael?
So I guess I'll say a couple, in terms of burdens of proof, I actually think there's just a general problem, which is, I think the courts, right, through common law, the courts have really, I think, redefined or changed the scope of antitrust. I mean, a lot of people tend to say, oh, the enforcers have been too timid, but it's extremely hard to win a monopolization case now. And it's actually, I think it's even hard to certainly win certain classes of merger cases. So I think one of the things we need to see is some sort of recalibration. And so that's not just even specifically to tech, but I think the presumptions the courts are making now, a lot of them are unfounded. They just sort of say, oh yes, this is obviously true empirically, but then they don't cite anything other than some other decisions that, oh, it's obviously true. So I think there is a need for sort of a general recalibration. I also think there are reasons that we need to be particularly concerned about, for big tech, for example, what happens with buying up nascent competitors or potential competitors. And so I think that is something that needs to get more attention. And again, I think that's something where in the current legal standards, it's extremely hard to do. And that maybe, I don't know enough about the mechanics of it, maybe we need legislation, but I do think it's sort of the overall burdens of proof, the presumptions have gotten too unfavorable, I think, to plaintiffs. And I think in particular, it's long been, too hard to bring potential competition or nascent competition considerations into a case.
So, well, how would you define who's a potential or a nascent competitor?
Well, I'm fond of saying, and others of us saying, antitrust is really fact intensive. And you look at these industries, I mean, I think it's right. If you said in the abstract, can I tell? No, it may be really hard for me. On the other hand, if there's an investigation and you see company documents saying, we want to pay, $10 billion for this company that no one on the streets ever heard of, but we happen to think has the technology that could end up leapfrogging us and wiping us out, then I'd say, hey, there's a potential competitor, and I should be worried if they buy them. But I think it really has to be fact intensive, and I think it's not. I don't accept the argument when people say, look, sure, there looks like that one, but maybe there are 20 other companies we don't know about. I don't see how that's consistent with the prices of some of these acquisitions. Now, when you start getting to really small ones, they say, well, they picked up, a company for $5 million. I agree, it's going to be extremely hard, and maybe we don't worry about those. But I think it's just really one of these things you're going to have to look at the facts of the particular case. But I don't think we should be saying, oh, this company doesn't have much of a market share now, therefore there can't possibly be a problem.
Can the judicial system possibly do this better? I mean, how can they forecast what may tend to lessen competition or tend to create a monopoly sometime into the future? I mean, like 1948, the Supreme Court insisted upon spinning the theaters away from the distributors just as television was coming into being, and did the distributors a huge favor by forcing them to sell their theaters before they became worthless.
So let me come back, because when I was talking with Microsoft, and I think somebody in fact asked the question, what did people make of the Microsoft case now? But there's people who would argue, say, look, the whole Microsoft case was misguided because middleware was never going anywhere, and it turns out ultimately the browser didn't replace the operating system, and even when Chrome has come in. However, I think from the little bit I've read of the record, and I have to say I'm a big detractor of people sort of armchair quarterbacking antitrust cases without really digging in the facts, but I'll do that anyway. What I'm seeing, though, Microsoft and the government both have the view that these things were a big threat, and that so Microsoft and the government both have been wrong, but Microsoft saw these things as a threat, and they were trying to stop them from competing. Right. And with hindsight, as I said, they were both wrong, but I think it was still right to bring the case. And I do want to say, because I've been saying how hard it is to have remedies, and I very much agree with Diana, and I never thought I'd say this after my experience at the FCC, but maybe we do need a regulator. But antitrust remedies are really difficult. But I think sometimes, and there are people who disagree with this, but I think sometimes you have to bring a case even though you don't think there's a good remedy, because you have to identify that the firm's done it. Now, you've got to be careful on that because you can impose big costs on firms. But the Microsoft case is one. I think you just say, look, certain elements of what they're doing, you just have to go after it if you think it's wrong. You can't say, oh, they're going to get away anyway, because I think it establishes a sort of a bad precedent. And this comes back again to, I think often in these cases, it's not really remedying the past behavior, because maybe you can't, but you're trying to deter future bad acts, possibly of a different sort.
Yeah, that's the most favorable reading of the Microsoft case, right? That deterred Microsoft from future anti-competitive activities.
Yeah, I agree. I agree that is probably the most favorable reading. And I said, there were problems with the government's case, and that's why I was alluding to it. They changed what their theory of the case was, it seemed to me, in the middle of the case. But I do think ultimately they came out with the right one.
Are regulatory remedies easier than antitrust remedies?
Well, it depends. It depends. Sorry, it all depends. I'm on record with John Quokka in our writings about the pitfalls and behavioral antitrust remedies. Forces the courts to act in ways that they're not designed to act as monitors and regulators, which is why structural remedies are always more effective. Of course, the ultimate remedy is to say no to potential, acquisitions and mergers and that kind of thing. That is the ultimate remedy that restores competition. But regulation is set up for compliance and monitoring. That's what regulators do. They do it 24/7. And they have a complaint process, and they have a proactive investigatory process. But when behavioral remedies come up against regulatory conduct type remedies, then you see some potential concerns. I do want to make one point about the whole paradigm of how we're looking at acquisitions in the digital ecosystems. I'm getting personally frustrated because I talk on a lot of panels, and this is not, I'm not talking about this panel, about applying traditional potential competition doctrine to the digital ecosystems. It really doesn't work very well. If you look back at the history of acquisitions by the big five, and I did this empirical work a couple of years ago and testified to it at the Senate hearings, you are looking at all different kinds of acquisitions, horizontal transactions, vertical transactions, but more importantly, you're looking at ecosystem transactions, building out the ecosystem by adding capability and competencies to generate and fortify that digital ecosystem value proposition. Those are very different than just potential acquisitions or horizontal or vertical or even conglomerate types of acquisitions. Antitrust has not yet jumped that hurdle. I've sat on dozens of panels applying potential competition doctrine to the digital ecosystems. That doesn't work very well. And we're really trying to kind of push past that to view these things differently in terms of burden shifting and new presumptions, stronger presumptions, and that sort of thing. And I think until we get there, we're still not going to have the best the best framework or set of analytics to look at how the digital ecosystems have become entrenched and how it will be very difficult to displace that.
In the digital world, if we become more aggressive on mergers, won't the focus shift to acquiring the human capital in these firms rather than the firms themselves?
Well, in fact, that's what, typically if you ask these companies, they'll say that's what the mergers are.
Sure.
These small ones. I know that's Google's public position.
Yep.
So we're going to have employment bans on hiring people away from startups?
Okay, I think we have pretty much run out of time. Does anybody have any last comments they'd like to make?
Any predictions on the outcomes of these cases?
I don't know if everybody wants to do that.
I actually I predict that people will disagree on whether the outcomes were good or bad.
Good prediction.
Well, Bob, do you want to predict whether the government will win any of these cases?
I'm not a lawyer. Ask Randy.
No. The prediction I want is when do we actually think we will have an endpoint to these cases, right? That goes back to what Michael was saying earlier, right? The timeline Michael laid out. I laid out IBM. He laid out Google Shopping. That's a decade and ongoing. And I think Europe has accomplished nothing there, right, in any meaningful way. So look, the trial in the Google case isn't scheduled, I think, until the fall of, is it 2023? It's extraordinary. Right. So I don't know who's going to win. I don't know who's going to lose, but we're going to see regulation, especially in Europe, before we're going to see antitrust results in the United States.
Will we see, this is a prediction, will we see regulation in the United States?
Okay, there's your answer. Diana's shaking her head.
I didn't see that. Did you shake
that was a yes.
That's a yes. Okay.
Yeah, I think that's the biggest public policy issue. These antitrust cases are vitally important, but the big public policy issue is crafting some sort of regulatory regime. There are many challenges to be met in getting through that, as any former regulator in telecom, electricity will tell you.
There is no way these cases will be resolved in any meaningful way during the first Biden term. So, not a chance, I think.
So, well, this has been a great discussion. I want to thank you all for participating, and thanks to our audience.
Thank you.
Thank you.
Thanks for having us.